Now, the government is introducing new restrictions for no-win, no-fee legal cases, arguing there's been an explosion in lawyers' fees. The Justice Secretary, Kenneth Clarke, said the cases have become a terrible burden for businesses which are sued and organisations like the NHS. So is this a sensible move to restrict ambulance-chasing lawyers, as the media often dubs them, or trying it on, or a denial of justice, for those who suffer an accident? Well, victorious lawyers in a no-win, no-fee case will now get paid from the damages awarded to claimants rather than from losing defendants. This figure will also be capped at 25% of the total damages awarded by a court. The government has also launched a consultation on expanding an online system of resolving cases between lawyers and insurance companies aimed at slashing waiting times and legal expenses, a form of mediation. I'm joined now from Westminster by the Justice Minister, Jonathan Djanogly. Mr Djanogly, you have upset personal injury lawyers. I'm sure you won't be surprised to hear. They say no win, no fee may be unpopular with you, but it does work, and as a result of the changes you're making, fewer people will access justice.
We don't think that fewer people who deserve to go to justice will have that taken away from them. But we do need to address the question of the compensation culture in our country.
Well, hang on this point, first of all, before we come on to that, sorry, Mr Djanogly, if we can address this issue of affordability and people on limited means who, at the moment, take advantage of a no-win, no-fee claim to put their claim forward, they will be deterred from doing that because in future there may well be fees.
No, they won't be deterred from doing that because we're not getting rid of their ability to have a no-win, no-fee deal. What we're stopping is that the markup on the fee that's won should be taken from the losing defendant.
Sure,
what that means in reality, can I just explain that, because it's an important point. What that means in reality is that under the current system, claimants have no interest in the costs of the case. So they don't look to see who's offering the cheapest services for legal services, and they don't really care what happens in terms of the costs, which means that when they see an advert, say, on the television, there's absolutely no reason at all why they shouldn't just have a go, and that's creating a mechanic that is leading to a compensation culture.
OK, there is a survey that's been carried out this evening by a firm called Contact Law, who put people in contact with solicitors. They've polled 100 solicitors, and of them, 69% said they will continue to offer no-win, no-fee cases. However, they will ask for a kind of financial contribution on more marginal claims. It's clear there will be costs, and it's clear that presumably people with perfectly legitimate claims may well be deterred because they fear it's prohibitively expensive.
Well, it's the more marginal claims which are the ones we should be concerned about. If it's a straightforward claim, then they'll go to a solicitor and the solicitor will take the case. If it is a marginal claim, then what we're saying is that those cases should not necessarily proceed. The claimant and the solicitor's interests should be aligned, which is what we're going to do, so they think very carefully before taking the claim forward.
How can you guarantee that the result of this will not be that employers who, for example, have shoddy work practices go unpunished?
Well, if they have shoddy work practices, then it may well be a criminal issue rather than a civil issue. But if there's a straightforward case, they will still have the opportunity of a no-win, no-fee deal. But we have to also look at the other side of the coin, which is that businesses are being closed down. Larger businesses which can self-insure are having to add money to the price of the products to pay for the insurance. Motor insurance is going through the roof because of an excess of claims, and we have to deal with this.
OK, Justice Minister Jonathan Djanogly, thank you very much for joining me to discuss that. Joining me here in the Gherkin is Dan Watkins from Contact Law. I mentioned the survey which matches claimants to solicitors, and Bertie Lee, a senior partner at Hempson's law firm, who acts for the NHS and other healthcare bodies. I want to start with you, if I can, about the forward by the Prime Minister to an investigation carried out into this issue. And the Prime Minister says a damaging compensation culture has arisen, as if people can absolve themselves from any personal responsibility for their own actions, with the spectre of lawyers only too willing to pounce with a claim for damages on the slightest pretext. The point the Justice Minister was making there does need to be reformed, doesn't there?
I think it's about doing these things with a measure of balance. We're in real danger of bringing in these changes and the law of unexpected consequence coming in. If if we bring in the changes exactly as they are now, you're going to make cases less profitable for lawyers to run through the mechanisms they've just outlined. That means that less lawyers are going to offer them. It's just simple economics, and therefore, as our poll, which you referred to earlier, shows, from those firms we spoke to, 70% are going to be looking for a financial contribution towards the cases, and that will deter people from seeking justice.
But we've got to a situation where the fees that lawyers are charging exceed the damages that courts are awarding. Your members, your people you deal with, have got too greedy.
I think in all industries you're going to get cases which are extreme, and where you'll find people bringing claims, a small value compensation at the end of it and a lot of legal fees, but they are a very small minority of the overall cases, and I don't think we should be looking to radically change a whole industry which is delivering complete consumer access to justice just because of a relatively small minority of cases. As for compensation culture, I would say the Minister keeps talking about marginal claims, but actually, is it marginal if you had an injury at work and you're not able to get evidence simply because maybe your employer is withholding it from you, making it difficult? You don't have much evidence for that claim, but it's still a genuine bona fide claim, so it is marginal from a lawyer's point of view. Why should those people not get access to justice?
OK, Bertie Lee, you've acted as an advisor to the NHS, which has experienced this firsthand. The majority of fees paid to lawyers are reasonable. The excessive fees are in the minority.
Well, you've got to realise that the proposals that come out today follow a very careful, detailed inquiry by Lord Justice Jackson, which took place over a year ago. And Lord Justice Jackson had a survey carried out of relationship of damages and costs, and he found that on CFA cases, on average, they were between 158 and 203% of the damages. So it's not true that it's a small minority, I'm afraid. It is the typical case carried out on a CFA. If a person with a claim goes to see a lawyer now, they are sold, first of all, a success fee. They have no interest in what the base costs are because they know they're not going to be paying them whatever happens. They sign a contract whereby they agree to pay a success fee. They're told that whatever happens, they're not going to have to pay it. They're then sold an after-the-event insurance policy with a massive premium attached to it, equivalent to the whole of the costs of the defendant. And they're told, don't worry, whatever happens, you're not going to have to pay it. So you end up with a system in which the claimants are getting very high costs already, then they're doubled for the success fee, and the defendant has to pay the after-event insurance policy.
But isn't a system, however flawed like that, preferable to one in which you may find that claimants aren't actually able to access justice because they cannot afford it?
Well, we do not live...
Or they fear they cannot
Sorry,
afford it.
we do not live in a perfect world. I believe passionately in access to justice. That does not mean compensation for every imagined wrong. The Secretary of State says today that a system of justice, of civil justice, is part of the cornerstone of any civilized society. And I believe passionately that he is right, that when somebody has a wrong, they have a right to go to the Queen in the form of a judge and say, try my case according to the law. They do not have a right to go up to a fruit machine and pull a lever knowing that every claim will be paid out.
And that's bringing you back in here. That's precisely what the system is at the moment. It is a lottery. It's lawyers. There's an incentive there for lawyers simply to have a punt on a case in the off chance they might get lucky.
I would disagree with that premise. Everyone in the industry is geared up to not take things on speculatively. The companies who are marketing and referring clients to law firms were paid fees, but only if a case is won. Lawyers only get their fees if they're won. They're not going to take on spurious cases, which they know they're not going to win. It's not a jackpot lottery. They have to assess the case before they decide to run it and take it to court, and they will only take on the ones that they think they're going to win.
And briefly, Mr. Watkins, the result of this reform will be, in your opinion?
Reduced access to justice for consumers, particularly lower-income groups who can't afford to chip in £1,000, whatever it might be, for an injury claim.
There may be a few less claims. I doubt it. I should have thought that we're likely to have a better balanced system in which people do get access to justice and a right to put their claims before the courts.
OK, Bertie Lee, Senior Partner at Hempson's, who's acted on behalf of the NHS. Thank you very much. And also Dan Watkins from Contact Law.